Okay, so in today's lecture, we'll be doing chapter 7 of business studies, that is formation of a company. This will be a one shot lecture, we'll be completing the entire chapter. In the previous chapter, forms of business organization, in the last form, we studied about joint stock company. So, this is a continuation of that. You will be seeing how a company gets formed. First, we must understand that there are three distinct stages in the formation of a company. First is promotion, second is your incorporation, and third is your subscription capital. Subscription of capital is only done by your public company, okay, because whenever you have to subscribe for capital, that is only done when the shares are allotted to the public. So that is done only with your public company. Let's start the chapter. So first we are going to study promotion of a company. So, promotion is the first stage in the formation of a company. It involves conceiving a business idea, means making a business idea. First, you think of a business idea that I want to start a company of, say, anything. So, you pitch a business idea and taking an initiative to form a company so that practical shape can be given to exploit the available business opportunity, whatever idea that you think, to give it a practical appearance, you form a company. So basically what happens in this is you have your promoters. What is a promoter? A promoter is said to be the one who undertakes to form a company, means he himself or herself takes the responsibility to form a company with reference to a given project and to set it going, and who takes necessary steps, who takes the steps to accomplish the purpose of starting up the company. So, apart from conceiving a business opportunity, the promoter analyzes its prospects. Promoter just doesn't make a business opportunity. It also it also analyzes that what are its prospects, how is it, will it be beneficial, will it be something that will have a continuity. So and uh, and they also bring together the men, material, machinery, managerial abilities, and financial resources, and set the organization going. So, as per section 69, a promoter means a person who has been named as such in a prospectus. So, he or she has to be named in the prospectus. He or she should have control over the affairs of the company. Lastly, in accordance with whose advice, directions, or instructions the board of directors of a company is accustomed to act. So, as per the directions of the promoter, the board of directors of the company are supposed to work, are supposed to act. So he is basically the guiding light. He gives his instructions, his views. On those basis, the board of directors of the company work. After thoroughly examining the feasibility of the idea, the promoters assemble resources, they prepare necessary documents. So, firstly, they examine the idea, what business idea is there, they thoroughly examine that. Then, they prepare necessary documents, they give a name and perform various other activities to get the company registered and to obtain the necessary certificate that enables the company to commence business. Thus, the promoters perform various functions to bring a company into existence. They are basically known as the backbone. They are the one who they are the initial formers of the company. Then we are going now, let's see the functions of promoter. So there are several functions of promoter. First is identification of business opportunity. First and foremost, the activity of promoter is to identify the business opportunity, and the opportunity may be in respect of producing a new product or service, or making some product available through a different channel. So it may be, opportunity can be either you're making a new product or the existing product is getting innovated. So such opportunity is then analyzed to see if it is technical and economically feasible. Okay. Second function is your feasibility study. So under this we are going to see, no, mainly we are going to see three types of feasibility studies. So feasibility studies is that always it is not possible or it's not feasible to convert all the business opportunities into real projects. Whenever we think of a business opportunity, we have to see if it's feasible. Not always whatever you think can be feasible, right? Maybe you think of a business idea that involves a lot of money, a lot of effort, so that might not be financially feasible for you, right? So it is not always feasible or profitable to convert all the identified business opportunities into real projects. So the promoters therefore undertake detailed feasibility study. They study in depth of how the company, how it should be executed in a way that it is feasible. Depending upon the nature of the project, the following feasibility studies may be undertaken with the help of specialists like engineers, your chartered accountants, to examine whether the business opportunity that you are thinking of is profitably exploited, can be profitably exploited. So first is your technical feasibility. Sometimes an idea may be good but technically not possible to execute. Maybe sometimes your idea is very good, your idea that you're thinking of might be really good, but it might not be technically possible. It may be so because the required raw material or the technology is not easily available. For example, we had studied before that Avatar needs a particular metal to produce a carburetor or some machine, you can say. If that metal is not produced in the country only, then because of poor political relations or any reason for that matter, the project will not be technically feasible, right? It would be technically unfeasible until arrangements are made. Until and unless the arrangements are not made, will it be feasible? No, because you're not getting that in your country. So until and unless arrangements are made to make the metal available, only then you can make your business work. So technical feasibility has to be there. Second is financial feasibility. This is one of the most important aspect. Every business activity requires funds, right? It's not always that what you think of is affordable, uh, just to your borrowings, or just to what how much you have. Sometimes it might be you need to take funds, you have to take loans. So promoters have to estimate the fund requirements for the identified business opportunity. They think in depth, they study in depth that how much would be required to execute this project. If the required outlay for a project, say 5 lakh or 10 lakh, is so large and it cannot be easily arranged within the available means, the project has to be given up. You can't. For example, one may think that developing townships is very lucrative. Lucrative basically means very profitable. But it may turn out that the required funds, means the amount that you have is not, are in several crores, which cannot be arranged by floating a company by the promoters. Floating a company means listing the company, registering the company. So the idea may be abandoned because of lack of financial feasibility of the project. Third study of feasibility or feasibility study is your economic feasibility. This is also one important aspect that needs to be taken in care when you are starting up a business or when you think of a business idea. So sometimes it so happens that the project is technically viable, means it is technically feasible also, and it is financially feasible also, but the chance of it being profitable is very little. Both aspects, there are three aspects among, out of those two is being fulfilled, but there might be a chance that it is not that profitable. In such causes as well, the idea has to be abandoned. Economic means profitable or not, is the idea profitable or not. So in such cases also, the idea would have to be abandoned. So promoters usually take the help of experts to conduct these studies. So it's not necessary that the promoters that a company, see promoter, he undertakes himself, means the company is not hiring a promoter, okay. But you should know that a promoter is not an expert. He or she is just a mere, you can say, is just a agent. But you need a expert also. So promoters, they take the help of experts to conduct these studies. It may be noted that these experts do not become promoters. The experts cannot be called promoters because they are assisting promoters in studies. Just because the experts are assisting promoters, they cannot be called promoters. This must be noted. So can experts be called promoters just because they're helping promoters? False. Okay, only when these investigations throw up positive results. So only if you're pitching a business idea and these three uh, studies, your feasibility studies are satisfied, only then the promoters decide to actually launch the company. Otherwise they will work in that aspect. And if the company, if the company, after working on that thing, if the company is still not showing results or is still not rising, then they will abandon that idea completely. If there are some positive results, then it goes ahead with launching the company. Third function of promoter is name approval. So having decided incorporate to a company, the promoters have to select a name and have to select a name for it and submit an application to the registrar of companies. So this is important. Whatever submission of documents or whatever submission has to be done is done to the registrar of companies. It's basically a formal association of companies which take up legal documents what are required to form a company. So when your company gets incorporated, finally the promoters have to decide a name and submit it in an application to the registrar of the companies of the state in which the registered office of the company is to be situated. So, the proposed name may be approved if it is not considered undesirable. So, it's not necessary that, okay, before that, let me tell you, there are three names that are given. Three names have to be given. Out of those three names, the registrar of the company decide what is suitable. Say out of those three names, two were misleading or undesirable, so the one name that was considered desirable is considered second option is, if all three are desirable, all three are okay, then your promoter gets to decide what is the most appropriate suited name for your company. So, the proposed name may be approved if it is not considered undesirable. So, it is not necessary that the name that you are given is always selected on first come, first base. No, it might get rejected if it is considered undesirable. It may happen that another company exists with the same name. It is not possible that your company and some other company have the same name, right? So if your name and the other company's name is matching, it might be considered undesirable, or it's a very similar name, or the preferred name is misleading to suggest that the company is of a particular business when it is not true, means you are naming your company in such a way telling people that it is of a clothing brand, but in actual it is of a liquor brand, suppose. So this is misleading. So in such cases the proposed name is not accepted. So if your name is same as some other business, or is very similar to some other business, or is misleading, so in these cases your name will not get approved. And your name will not get approved, and some alternate name will be approved. Therefore, three names in order to of their priority are given in the application. So the promoter will give three names. First one will be the most what the promoter thinks should be the name of the company. Then he gives the second name in case the first name gets rejected. So second option is there. Then third option is there. So according to the in order of priority, the names are given, and three names have to be given to the registrar of the companies. Okay, then your fourth function of your promoter is fixing up signatories to the memorandum of association. So MOA, memorandum of association, which is also known as MOA, is basically the objectives. It lists down the objectives. So fixing up signatories to the memorandum of association means to sign the document. So promoters have to decide about the members who will sign the MOA of the proposed company. Usually when we see, usually people signing memorandum are also the first directors of the company. Those people who signed the memorandum are known as the first directors of the company. Their written consent to act as directors and to take up shares in company is necessary. Your fifth function of promoter is appointment of professionals. So, certain professionals, such as your bankers, your auditors, are appointed to promoters to assist them. Your promoter is not multi talented that they will do the work of a banker, auditor, or of an expert as a whole. No, they cannot do that. So, they are given professionals like bankers and auditors, so that they can assist them in preparation of necessary documents which are required to be with the registrar of companies. So the names, addresses of shareholders, number of shares, what is the name of shareholder, what is the address of shareholder, number of shares that are allotted to the shareholder, has to be submitted to the registrar in the statement called return of allotment. Name, address, and number of shares held by the shareholders have to be submitted to the registrar in the statement called return of allotment. Return of allotment. This is important. Then we have our sixth function, that is preparation of necessary documents. So after all these, you have to have your last function, that is preparing the necessary documents. So promoter takes up steps to prepare certain legal documents. Some legal documents have to be prepared which are necessary, which have to be submitted under the law to the registrar of the companies. Whenever they use the word law, that means something that is mandatory, has to be done for getting the document company registered. These documents are memorandum of association, articles of association, and consent of directors. Three documents: memorandum of association, articles of association, and consent of directors. Now we'll see what are the documents which are necessarily to be submitted, documents required to be submitted. First is memorandum of association. So we have memorandum of association. Under that we have four types of clauses. Under memorandum of association we have five type of clauses. Then we have articles of association, then you have consent of proposed directors, then we have statutory declaration agreement. So then you will have receipt of payment of fee, that is your last document to be submitted. So firstly, we are going to see memorandum of association. This is an important question. It usually comes as a 6 marker in your test. So memorandum of association is the most important document. It defines the objectives of the company, and no company can legally undertake activities that is not contained in the memorandum of association. So your MOA that is there, it defines or it shows the objectives of company. So no company can take undertake activities, means can do activities that are not written under the MOA. So as per Article 2, Clause 56, the the memorandum of association of a company as originally framed or as altered from time to time in pursuance of any previous company law of this act. The memorandum of association contains different clauses which are given as follows. So memorandum, so the Company Act, the Companies Act 2013 defines memorandum as memorandum of association of a company as originally framed or altered from time to time in pursuance of any previous company law or of this act. So the MOA contains different clauses which are given below. First is your name clause. So before reading name clause, we'll see this thing that has been given here. This is your name clause only, but it's in a better way, and this comes usually in your exam as a 3 marker. See over here, they've given you such a small chinto box over here, just this much. But actually, in your exam, this comes as a 3 marker, and it's important. So, a name is considered undesirable in the following cases. First of all, if it is identical or it's too closely resembles the name of an existing company. Secondly, if it is misleading, it is considered if it is so considered if the name suggests that the company is in a particular business or is an association of a particular type when it is actually not true. Third point, which is very very important, is if it is volitive to the provisions of the Emblem and Names Act 1915. This you have to learn as it is. So, if it is violative of the provisions of the Emblem and Names Act 1950 as given in Schedule to Act, this schedule specifies the name, emblem, official seal, etc. Government of India, state government, the President of India, governor of any state, the Indian national flag. The act prohibits use of name which may suggest any patronage of government of India. Patronage means under the privilege of government. It cannot be used by any commoner. Okay, so or any state government or any local authority. So you can't use the official seal or the emblem of that country basically. Now let's see what is name clause under MOA. So this clause contains the name of the company with which the company will be known. It contains the name of the company with which the company will be known, which has already been approved by the registrar of companies. Name approval is your first step. That is when your name goes to the registrar of companies for approval. Name clause is when your name has come to you as approved by the registrar of companies. Registered office clause, your second clause of MOA. So registered office clause is basically this clause contains name of the state registered or in which the registered office of the company is situated, exact address of the registered office, registrar within 30 days of the incorporation of the company. So basically what happens is the exact address of the registered office is not required. Usually exact address of the registered office is not required at this stage, but the same must be notified to the registrar within 30 days of incorporation of the company. Your third clause is your objects clause. So objects clause is one of the most important clause of the memorandum. Why? Because it defines the purpose of the company. See, if you don't know what is the purpose of the company, then there is no use of having a company. So object clause is very important. Purpose why the company is formed, you get to know the purpose for which the company is formed. A company is not legally required to be a company is not legally entitled to undertake an activity which is beyond the object stated in this clause. So this is your object clause. Then you have your second last clause, that is your liability clause. So the name suggests this clause limits the liability of the members to the amount unpaid on the shares owned by them. Okay, so for example, if a shareholder has purchased 1,000 shares for 10 rupees each and already has paid rupees 6 per share, his or her liability is limited to rupees 4 per share. Thus, even in the worst case, he or she may be called upon to pay how much? Only rupees 4,000. Okay, then you have your last clause, that is your capital clause. So this clause specifies the maximum capital which the company will be authorized to raise through the issues of share. Maximum capital. This table that you see, these two tables, this is not coming. So then they have given you an example over here as well. Then so you the example is not that important, you can read it, it's not that important. Then you have your articles. Then you have your next document that is required to be submitted. It is articles of association. MOA we studied. Under MOA we studied for five types of clauses. We studied name clause, registered office clause, object clause, liability clause, capital clause. Name clause, registered office clause, object clause, capital clause, and liability clause, capital clause. Okay. Next, we are going to see articles of association, which is called your AOA. So, articles of associations are rules. MOA, your memorandum of association, is the objectives. Articles of associations are the rules regarding the internal management of a company. When we go later on, we'll be seeing this difference table. It is later only you will be seeing. So in this different table, you will be seeing your MOA it defines relation with the company with outsiders. Matlab, it's the external external relationship that is being defined in MOA. But AOA, on the other hand, it defines relationship within the members of the company. MOA external, AOA internal relationships. Okay, so then you have your articles. So this defines, it's the rules regarding internal management of company. So these rules are subsidiary to the MOA. Means first you will read the rules of MOA, then you consider your AOA, and they should not contradict or exceed anything that is in MOA. Suppose MOA is saying something, AO is saying something that is exceeding your MOA, that is not possible. So, according to Section 2, Clause 5 of the Companies Act 2013, articles means article of association of a company as originally framed or as altered from time to time or applied in pursuance of any previous company law or of this act. Okay, then all this you don't have to read. Moving on, your third document is your consent of proposed directors. So you should, the promoters have to decide what are the directors that have to be put forward. So apart from MOA and AOA, a written consent of each person named as director is required, confirming that they agree to act in capacity and undertake to buy and pay for qualification shares as mentioned in the articles of AOA. So your director of the company is required to confirm that they are in the capacity, means they are able to undertake and to buy and pay the for the shares. Okay, then your fourth document is your agreement. After agreement, you have statutory declaration, and lastly, you have the fees, the required fees that is there. So agreement, if any means it is not necessary, but if any is there, which the company proposes to enter with any individual for appointment as its managing director or a whole time director or manager, another document is required to be submitted. So if a company wants to have a managing director or a whole time director, another document has to be submitted to the registrar for getting the company registered under the act. Then your fifth document is statutory declaration. Statutory declaration means what is statutory? By law. As I said, law, whenever the word law comes, means it is necessary, compulsory. A declaration stating that all the legal requirements pertaining to registration have been compiled with, see, all these documents that are required in the exam, you have to write in the same steps. You can't write first point as statutory declaration, because the rest before statutory declaration, the four other documents that are required have to be given first to the company registrar of companies. Only then you get your registration complete. Only then statutory declaration comes. So you cannot mix up the order. So, statutory declaration, a declaration stating that all the legal requirements pertaining to the registration have been compiled with is to be submitted to registrar with the above mentioned documents, whatever documents we have done till now, for getting the company registered under the law. This statement can be signed by the advocate or a chartered accountant. Okay, so this is it from here. Then we have our last point, which is receipt of payment of fees. So along with above mentioned documents, whatever documents we have studied now, when these get validated by the registrar of companies, your necessary fees has to be paid for the registration of the companies. This was the whole purpose of the topic, right? What was the topic? Documents required to be submitted for the registration of company. So necessary fees has to be paid for registration of company. The amount of fees shall depend on the authorized share capital of company. So how much share capital you have, according to that your fees is being determined. So with this we are done with documents required to be submitted, and then in this page your this full thing, this box, big box is cut. The small box is very important. It comes usually as a 2-3 marker. So qualification shares, to ensure that directors have some stake in the proposed company, the articles usually have provision requiring them to buy a certain number of shares. You have to buy a certain number of shares to ensure that directors have some stake in the company. Stake means some a position in the company. Okay, so they have to pay for these shares before the company obtains certificate of commencement of business. These are called qualification shares. Okay, to ensure that directors have stake in proposed company, articles usually have a provision requiring them to buy a certain number of shares. They have to pay for these shares before the company obtains the certificate of commencement of business. These are called your qualification shares. Next topic that we have is position of promoters. This again is not coming, this is deleted portion. Next we are going to see incorporation. So this is your second step of the stage of formation of company. First step is position of the company. First step is your position of the company. Then you have your promotion of company, sorry, then you have your incorporation, and then you have your capital subscription. So incorporation basically means, after completing the aforesaid formalities, whatever formalities are there, you have to, after completing all of this, promoters make an application for incorporation of company. Application is to be filed with registrar of companies of the state. So the application of the registration must be accompanied with certain documents about which we have already discussed in the previous section. These may be briefly mentioned again. So it's the same they are mentioning again. Whatever we studied till now, MOA, then we studied about AOA, then you studied about written consent and all of that. All of that is being repeated over here. Consent of directors, agreement, statutory declaration, fees, all that we studied here is being you must know memorandum of association has five clauses that we have done. First is name clause, registered office clause, object clause, liability clause, capital clause. Okay, so MOA, first MOA, it should be duly stamped, signed, witnessed. In case of public company, seven members have to sign. For private company, two members are sufficient. Signatories has to give the information about their address, occupation, number of shares subscribed by them. Second, AOA, duly stamped, witness, as in case of MOA. Same way, it has to be stamped, witness, and it has to be signed. Okay. So, however, as stated earlier, a public company may, okay, this you don't leave it. So, in that case, a statement of view of prospectus is submitted instead of AOA. So, a public company also submits a statement of view. Statement of view is submitted before the prospectus. Before your prospectus is made, your statement of view is submitted instead of your prospectus. Third is written consent of the proposed directors to act as directors and an undertaking to purchase qualifications shares. Then fourth, agreement, if any, with the proposed managing directors has to be given. Then a copy of registrar letter approving name of company, statutory declaration affirming that legal requirements for registration have been compiled and duly signed. Then a notice about exact address of the office has to be submitted. So, along with these documents, however, if the same is not submitted at the time of incorporation, matlab, you had to submit, the company had to submit, but they didn't do. So, at that time, it has to be it's not submitted at the time of incorporation. It can be submitted within 30 days of the receipt of certificate of incorporation. Eighth and the last is documentary evidence of payment of registration fees. So the registrar, upon submission of the application along with the required documents, has to be satisfied that documents are in order and that all the statutory requirements regarding registration have been compiled with. However, it is not his duty to carry out investigation about the authenticity of facts mentioned in documents. So, see, there are cases where the documents that are submitted might be fake or might not be true as to the composition of the company. So it is not the responsibility or not the it is not the duty of the registrar to carry out investigation if the documents are real or fake, right? So when registrar is satisfied about the completion of formalities for registration, a certificate of incorporation is issued to the company. This is also known as your birth certificate. Certificate of incorporation is known as your birth certificate of company. Why? Because from this certificate only a company gets its legal existence. Okay, so with the certificate of incorporation may therefore be called the birth certificate of the company. Then you have preliminary contracts. So preliminary contracts means before contracts. Okay, this is also important. It usually comes as case study. So during the promotion of the company, promoters enter into certain contracts with third parties also on behalf of company. So these are called preliminary contracts or pre-incorporation contracts. These are not legally binding on the company. A company, after coming into existence, may, if it chooses, decide to enter into a fresh contract with the same terms and conditions to honor the contracts made by promoters. Note that it is not note that it cannot ratify a preliminary contract. A company cannot be forced to honor a preliminary contract. If it wants to honor the promoter, it can go with it. If it doesn't, it is its company's wish. Promoters, however, remain personally liable to third parties for these contracts. So, promoters will be personally liable to third parties for these contracts. Okay, then we have our effect of certificate of incorporation. This is deleted also. So till now, what is deleted? Position of promoter is deleted, and your effect of corporation is deleted, completely deleted. Next, we have our director identification number. This usually comes as a one marker, so it is important. Director identification number, also known as DIN. So every individual intending to appoint as director of a company, right, has to make an application for allotment of director identification number to the central government. He has to make an application to the central government in prescribed form with a fees. The central government shall allot a director identification number to the application within 1 month from the receipt of application. No individual who has already been allotted the DIN shall apply for, obtain, or possess another DIN number. So, if you're already been given a DIN, you cannot apply again for the same thing or the same process. Okay, so DIN is basically when you want to be appointed as the director of a company, you go for the application of the DIN to the central government. They give you a DIN number within 1 month. Okay, next, and your very important stage of formation of company is your capital subscription. This usually comes as a 6 marker in exam. Very, very, very important. Okay, in this you mainly capital subscription, as I already told you in the start of this class, that it is done by public company only. Okay, so under this you have mainly six types of steps to raise funds from the public. So public company can raise the required funds from public by issue of securities, shares, debentures. We have studied this. For doing the same, it has to issue a prospectus. Prospectus is like a invitation that is given to the public, like statement of lieu. Statement of lieu is also invitation, but statement of lieu is given before the prospectus is made. So, prospectus is an invitation to the public to subscribe to the capital of the company and undergo various other formalities. So, the following steps are required for raising funds from the public. There are mainly six steps that are involved. First is SEBI's approval. SEBI is no other than your Securities and Exchange Board of India, which is a regulatory authority in the country. Security and Exchange Board of India is a regulatory authority in our country and has issued guidelines for the disclosure of information and investor protection. So to disclose the information, because your subscription of capital is done in public company, and companies are mandatory, they have to disclose all the information to the public, because public people are the one who are investing their shares, their time, their knowledge, effort into the company. So they have to disclose the information, and they have to protect the investors rights, their everything related to investor. So a public company inviting funds from general public has to make adequate disclosure of the relevant information and must not conceal any material information. Means some important information that can affect the decision of the public should not be hidden by the company, by the public company. Prior approval from SEBI is therefore required before going ahead with raising funds from public. So you need to have approval from SEBI before going ahead with raising funds from the public. Your second step is filing of prospectus. So a copy of prospectus or statement of lieu of prospectus is filed with the registrar of companies. Your copy of prospectus or statement of view of prospectus is filed with the registrar of companies. A prospectus is any document described or issued as a prospectus, including notice, circular, and okay, this is not important. So you have to file. You have a company or prospectus or statement of view of prospectus has to be filed with registrar of company. Then you have appointment of bankers, brokers, and underwriters. Bankers are those this application money. The application money is to be received by bankers of company. Brokers, they try to sell the shares by distributing forms and encouraging public to apply for the shares. Brokers will try to sell their shares. Bankers, they the application of money to be received by bankers of the company. That is the function of bankers. Brokers will have to sell the shares, and underwriters are those who assure the company that the shares will be sold. They give a guarantee. Underwriters undertake to buy the shares if these are not subscribed by public. If the public is not subscribing to the shares, underwriters assure the company that they will take the shares, they will buy the shares. They receive a commission for underwriting the issue. Okay, means when the underwriters under when they undertake the issue, they get a commission for that. Appointment of underwriters is not necessary, so it is not necessary for company to have underwriter. If it wishes to do so, it can go ahead with it. Fourth step is your minimum subscription. So these all steps are to raise funds for the public company from the public. Minimum subscription means, see, for a company, it must have 90% is the minimum subscription for a company. So, in order to prevent companies from commencing business with inadequate resources, it has to be provided that company has to receive application for certain minimum number of shares before it goes ahead with the allotment of shares. According to Companies Act, this is called minimum subscription. As per the SEBI's guidelines, the limit of minimum subscription is 90% of the size of issue. Thus, if applications received for the shares are for the amount less than 90% of the share issue size, the allotment cannot be made and application or money received must be returned to the applicants. Fifth step is application to stock exchange. So an application is made to at least one of the stock exchange for permission to deal in its shares or debentures. If such permission does not get granted before expiry of 10 weeks from the date of closure of subscription, the allotment share becomes void, means it becomes nil, and all money received from the applicants have to be returned to them within 8 days. Last step is allotment of shares. Allotment of shares is basically till the time shares are allotted, application money received should remain in the separate bank account and must not be used by company. So till the time your shares get allotted, your money received should remain in a separate bank account and must not be used by the company. In case the number of shares allotted is less than the number applied for, or where no shares are allotted to the applicant, the excess application money, if any, is to be returned to the applicants or adjusted towards allotment money due to them. Allotment letters are issued to the successful allottees. Return of allotment signed by the director or secretary is filed with registrar of companies within 30 days of allotment. A public company may not invite public to subscribe to its securities. Instead, it can raise funds through friends. So, if it's not necessary that they invite public to subscribe to its securities, instead it can also raise funds from friends, relatives, private arrangement as done by private company. In such cases, there will be no need to issue a prospectus or a statement of lieu of prospectus that is filed with registrar at least 3 days before making allotment. Okay, now, so moving ahead with our last topic of this chapter, one person company. So, with the implementation of the Companies Act 2013, even a single person now could constitute a company under the OPC concept. So, the introduction of OPC in the legal system is a move that would encourage corporatization of micro business and entrepreneurship. So, it would encourage your making of your micro business, means the businesses are which are at a small scale or a small level, and entrepreneurship. So, rest you don't have to read. The characteristics also you can just learn one, two, three of them. First of all, it should be eligible. Only a natural person who is an Indian citizen and resident of India can be eligible to incorporate in a OPC and shall be a nominee for a sole member of a OPC. No person shall be eligible to incorporate more than one OPC or become nominee in more than one such company. That is formation of a company. Thank you.